3:47 this morning, inside a sealed chamber at the Supreme Court of the United States, Chief Justice John Roberts issued an order that has never been given to a sitting or former president in the 249-year history of American jurisprudence. Donald Trump has been ordered to testify under oath in a proceeding that his legal team spent the last 6 months trying to prevent. And according to 3 independent sources, 2 clerks with direct knowledge of the sealed filing, and 1 former Justice Department official who was briefed within hours of the order, Trump's attorneys are now engaged in what one source described controlled panic as they scramble to determine whether he can actually survive cross-examination without committing perjury or self-incrimination. I need you to understand the weight of what I am about to tell you, because this is not just another legal setback for Donald Trump. This is the moment when the protective barrier between a former president and the mechanisms of judicial accountability finally collapsed, and what happens in the next 72 hours will determine whether our legal system can still compel truthful testimony from someone who has built an entire political movement on the strategic deployment of lies. If you care about whether equal justice under law still means anything in this country, you need to subscribe to this channel right now and turn on notifications, because the emergency legal filings that will be submitted before sunset today will tell us whether Trump's team believes he can actually testify without destroying himself, or whether they will attempt a legal maneuver so unprecedented that it could trigger a constitutional crisis before the weekend ends. Here's what we know. The sealed order was filed at 11:43 last night and became accessible through PACER, the federal court's electronic record system, at 3:31 this morning before being removed from public view. Exactly 19 minutes later. During that narrow window, the document was downloaded by multiple legal observers, and I have been provided with detailed descriptions of its contents by sources who reviewed the filing before it was sealed again. According to these sources, Chief Justice Roberts is not requesting Trump's testimony. He is ordering it under a rarely invoked provision of federal judicial authority that allows the court to compel witness testimony when facts material to constitutional questions cannot be established through documentary evidence alone. The order specifies that Trump must appear for deposition within 14 days and answer questions under oath regarding 3 specific areas: his communications with military officials regarding deployment of federal forces during the January 6 Capitol attack, his personal knowledge of classified documents removed from the White House and stored at Mar-a-Lago, and his direct involvement in efforts to overturn state-certified election results through alternate elector schemes. 3 constitutional scholars, 2 from liberal institutions, 1 from a conservative legal foundation, all confirmed to legal analysts within hours that this judicial mechanism, while almost never used, represents lawful exercise of Supreme Court authority and cannot be appealed through conventional channels. Former federal prosecutor Andrew Weissman, who served on Robert Mueller's special counsel team, told MSNBC this morning that this represents the most significant legal jeopardy Trump has faced because, unlike written interrogatories or affidavits that lawyers can carefully craft, live testimony under oath with follow-up questioning creates exponential risk for someone whose relationship with factual accuracy has always been, as Weissman put it, flexible at best. Now let me show you exactly what happened and why Trump's legal team is treating this like a 5-alarm fire, because the timeline reveals just how badly they miscalculated their strategy. Let me walk you through exactly how we got here, because this did not happen overnight. This was a cascade of legal decisions, strategic errors, and institutional patience finally running out, and every single step was documented in court filings that paint a devastating picture. Start with December 14, 2024. The Supreme Court accepts cert on a consolidated case involving presidential immunity, executive privilege, and the scope of post-presidential testimonial obligations. Trump's legal team, led by John Lauro and Alina Habba, files a motion arguing that former presidents enjoy absolute immunity from compelled testimony regarding actions taken while in office. It's the same blanket immunity argument they have deployed in every legal proceeding, the same argument that has brought them months of delays across multiple jurisdictions. They believe the Supreme Court will rule in their favor, or at minimum kick the case back to lower courts for further proceedings, buying another 6 to 9 months before any testimony question gets resolved. January 9, 2025. The court hears oral arguments, Trump's attorneys present their case with confidence bordering on arrogance, arguing that compelling presidential testimony would create a dangerous precedent, allowing partisan prosecutors to harass former presidents indefinitely. But here's what most people do not know about what happened during those oral arguments. Chief Justice Roberts asked Trump's lead attorney a direct question that became the turning point in this entire case. Roberts asked whether there were any circumstances under which a former president could be compelled to testify under oath regarding potential criminal conduct. Lauro responded that the remedy for presidential misconduct is impeachment and conviction, not judicial compulsion of testimony. Roberts then asked a follow-up question that legal observers in the courtroom described as devastating in its simplicity. And if Congress declines to impeach or convict, does that mean the former president is simply above the law permanently? Lauro's response, according to the official transcript, was that the political process provides sufficient accountability. Roberts said nothing further during the arguments, but sources close to the court's deliberations say that exchange shaped everything that followed. February 4th. The court issues a unanimous decision rejecting Trump's absolute immunity claim in a 31-page opinion authored by Roberts himself. The decision is narrow and surgical, holding that while former presidents retain certain privileges regarding confidential communications and executive deliberations, they enjoy no immunity from testimonial obligations when testimony concerns potential criminal conduct unrelated to core constitutional functions. Legal scholars call it a landmark ruling that fundamentally reshapes post-presidential accountability. Trump's team calls it a betrayal by Roberts and immediately begins strategizing how to avoid actually complying. February 11th. Special counsel Jack Smith, who has been waiting for this decision, files a motion requesting that Trump be compelled to provide testimony under oath regarding the 3 specific areas now outlined in Roberts' order. Trump's attorneys file an emergency motion, arguing that even if testimonial immunity does not exist as a blanket principle, specific executive privilege claims protect each of the 3 subject areas Smith wants to explore. They're trying to win on the details what they lost on the principle. February 18th. That brings us to last night at 11:43, when Chief Justice Roberts personally issued the order that shattered Trump's final protective barrier. The order is only 7 pages, but sources who reviewed it describe the language as unusually pointed for judicial writing. Roberts explicitly states that Trump's executive privilege claims regarding the 3 specified areas are rejected because the questions involve potential criminal conduct rather than legitimate executive deliberations. The public interest in testimonial truth outweighs any residual privilege concerns, and further delay serves no legitimate legal interest and appears calculated solely to avoid accountability. That last phrase, sources say, represents Roberts making clear that he understands exactly what Trump's legal strategy has been and that the Supreme Court will no longer enable it. Now, before we get to what happened next, I need to tell you about the man at the center of this decision, because understanding John Roberts is essential to understanding why this moment matters. Roberts was nominated by George W. Bush in 2005 and has served as Chief Justice for nearly 20 years. Throughout his tenure, he has positioned himself as the court's institutionalist, the justice most concerned with preserving the Supreme Court's legitimacy and public standing. He voted to uphold the Affordable Care Act despite conservative opposition. He has pushed back against the most aggressive attempts to dismantle voting rights protections. And critically, he has watched Donald Trump attack the judiciary, call judges partisan hacks, and systematically undermine public faith in the legal system's independence. Sources who know Roberts describe him as deeply concerned that Trump's systematic defiance of legal norms represents an existential threat to judicial authority. For Roberts, this is not about politics. This is about whether federal courts can still compel compliance from powerful individuals who believe they operate above the law. And by issuing this order personally, rather than assigning it to a lower court, Roberts is sending an unmistakable message. The Supreme Court will not allow a former president to simply refuse judicial accountability through endless procedural maneuvers. Which brings us to this morning at 6:22, when Trump's legal team held an emergency conference call that sources describe as bordering on chaotic. According to 2 people briefed on the call, the team is divided on strategy. One faction wants to file an emergency motion for reconsideration, arguing that the order was issued without sufficient opportunity to brief the court on specific privilege concerns. The other faction believes that strategy will fail and will only antagonize Roberts further, making him more likely to impose sanctions or hold Trump in contempt if there is continued resistance. The fundamental problem Trump's attorneys are grappling with is this. If Trump testifies, he faces enormous perjury risk because his public statements about January 6th, the classified documents, and the election overturn efforts contradict the documentary evidence that prosecutors have assembled. But if Trump refuses to testify or attempts to invoke Fifth Amendment protection against self-incrimination, it creates devastating political optics and potentially allows prosecutors to draw adverse inferences in civil proceedings. One source familiar with the discussions told us that Trump himself is insisting he can testify and handle any questions prosecutors throw at him, while his attorneys are trying to explain that courtroom testimony under oath is fundamentally different from rally speeches or Fox News interviews where factual accuracy is optional. And here's what concerns me most about where this is heading. Trump has spent the last 8 years building a political movement based on the premise that rules, norms, and legal constraints simply do not apply to him. His entire post-presidency strategy has been delays, appeals, and procedural maneuvers designed to push accountability beyond the next election cycle, beyond public attention, beyond the point where consequences can actually materialize. But John Roberts has now called that bluff in the most direct way possible. This is not a request that can be appealed to a more sympathetic court. This is not a ruling that can be overturned through political pressure. This is the Chief Justice of the United States Supreme Court ordering compliance, and there is no higher authority to run to. What happens when someone who has never accepted accountability finally encounters a situation where defiance is no longer possible? If you're finding this analysis valuable, hit that like button right now, because this story is about to get significantly more complicated, and you'll want to be here for all of it. But wait, there's something even worse I haven't told you yet. According to sources familiar with the sealed portions of Roberts' order, the Chief Justice included a specific provision that Trump's team is treating as catastrophic. The order states that if Trump fails to appear for the scheduled deposition or refuses to answer questions on grounds other than specific privilege claims evaluated and approved by the court in advance, he will be held in civil contempt with daily financial penalties of $100,000 until compliance is achieved. More significantly, the order states that criminal contempt referral to the Department of Justice will be automatic if non-compliance extends beyond 72 hours from the deposition deadline. Legal observers are calling this the most aggressive enforcement mechanism ever attached to a testimonial order involving a former president, and it reveals just how seriously Roberts is taking the possibility that Trump might simply refuse to comply. Constitutional law professor Lawrence Tribe from Harvard Law School told reporters that this provision transforms the question from whether Trump can be compelled to testify into whether Trump is willing to face contempt sanctions that could include criminal prosecution and potential imprisonment. That is not hyperbole. That is the explicit framework Roberts has now established. And it gets worse. Within hours of the order becoming public through the Pacer leak, Trump posted on Truth Social calling Roberts a radical leftist who has betrayed conservative principles and demanding that Congress impeach him immediately. Legal ethics experts describe this as potentially the most dangerous thing Trump could have done, because it gives Roberts every incentive to enforce the order strictly and demonstrates exactly the kind of lawless defiance that justified the order in the first place. Former appellate judge Patricia Hammond, now retired, explained that judges have enormous discretion in contempt proceedings, and when a party subject to judicial authority publicly attacks the judge's legitimacy while the order is pending, it removes any inclination toward leniency or accommodation. Trump just turned this into a direct confrontation between his personal authority and the institutional authority of the Supreme Court, and there is no scenario where he wins that confrontation. If Roberts decides to push enforcement to its conclusion, here's what I'm watching for in the next 72 hours that will tell us everything about where this is heading. First, watch for emergency motions filed by Trump's legal team. If they file for reconsideration or attempt to challenge the enforcement provisions, it signals they believe Trump cannot actually testify without self-destructing. Second, watch for any indication that Trump is seeking new legal representation, Sources suggest that several attorneys on his current team are privately advising compliance while Trump is demanding defiance, and that tension could lead to resignations that would throw his defense into chaos. Third, watch for statements from Republican elected officials. If Trump's congressional allies begin distancing themselves or refusing to support his attacks on Roberts, it suggests they have concluded this is a battle Trump cannot win, and they do not want to be associated with his defeat. The next 72 hours will determine whether we see compliance, defiance, or some desperate attempt at a middle path that satisfies neither legal requirements nor Trump's ego. So what does this actually mean going forward? Let me lay out the 4 scenarios that are now on the table, and I want you to understand that each of these is a real possibility with dramatically different implications for American democracy. Scenario 1. Trump complies and testifies. Probability 15%. In this outcome, Trump's attorneys convince him that defiance will lead to contempt sanctions and potential criminal prosecution, and that his only option is to appear for the deposition and invoke specific privilege claims on individual questions while answering others. The testimony creates devastating sound bites as prosecutors ask about his knowledge of classified document storage, his communications about deploying military forces against American citizens, and his personal involvement in schemes to overturn state-certified elections. Even if Trump avoids explicit perjury, the testimony becomes the centerpiece of multiple criminal trials and provides prosecutors with admissions that can be used against him for years. If this happens, it represents a watershed moment where a former president is finally subjected to the same testimonial obligations as any other citizen. Scenario 2. Trump refuses to testify and faces contempt sanctions. Probability 40%. This is the most likely outcome based on Trump's historical pattern of defiance when faced with accountability mechanisms. Trump refuses to appear for the deposition. Roberts initiates contempt proceedings with the daily financial penalties and criminal contempt referral, and we enter a protracted legal battle over whether the Supreme Court can actually enforce its orders against a former president who commands a fanatical political base. This scenario creates a constitutional crisis, as Trump's supporters frame judicial enforcement as political persecution, while legal scholars warn that failure to enforce the order would establish that former presidents are effectively above the law. The implications are catastrophic for institutional legitimacy, regardless of how the crisis resolves. Scenario 3. Trump attempts to testify, but invokes Fifth Amendment protection. Probability 30%. Trump appears for the deposition as ordered, but invokes his Fifth Amendment right against self-incrimination on virtually every substantive question, effectively nullifying the testimony, while technically complying with Roberts' order. Prosecutors argue this represents bad faith compliance and seek sanctions, while Trump's team argues that Fifth Amendment invocation is constitutionally protected and cannot be punished. The legal question becomes whether Roberts' order can compel testimony that overrides Fifth Amendment protections, potentially creating Supreme Court review of its own order's constitutional validity. This scenario represents a middle path that creates legal chaos while avoiding the direct confrontation of outright refusal. Scenario 4. Trump's legal team negotiates a narrow testimonial scope in exchange for cooperation. Probability 15%. In the least likely but potentially most significant outcome, Trump's attorneys successfully negotiate with prosecutors to narrow the testimonial scope to specific questions that Trump can answer without self-incrimination, in exchange for his agreement to testify without invoking Fifth Amendment protection. This scenario requires Trump to show restraint and accept limits on his public narrative, both of which are contrary to his entire psychological makeup. If this occurs, it suggests Trump's legal team has finally convinced him that this is a battle he cannot win through defiance, and that minimizing damage through controlled cooperation is his only viable strategy. But here's why this matters beyond one deposition or one former president's legal jeopardy. The stakes go far beyond whether Donald Trump personally faces consequences for potential criminal conduct. This is a stress test on whether American institutions can still enforce basic accountability when powerful individuals decide that compliance is optional. We have watched for 8 years as Trump systematically tested every norm, every legal constraint, every institutional guardrail, always finding that defiance was rewarded with delays, that outrage was met with procedural accommodation, that the rules bent when he pushed hard enough, John Roberts has now drawn a line and said this far and no further. What happens in the next 72 hours will determine whether that line holds or whether we confirm that institutional authority is meaningless when confronted by someone willing to defy it with sufficient shamelessness. If Roberts backs down, or if Trump successfully defies this order without consequences, we will have established conclusively that a former president with sufficient political support operates above the law in every practical sense. If Roberts enforces the order, and Trump is compelled to testify or face imprisonment for contempt, we will have re-established that judicial authority still means something, even when confronted by a cult of personality that treats legal compliance as negotiable. So what can you actually do about this? Because I know many of you are watching this feeling angry, feeling helpless, wondering whether institutional accountability is even possible anymore. First, contact your senators and representatives. Tell them that judicial independence matters, that the Supreme Court's authority must be respected regardless of whose political interests are affected, and that any attempt to impeach Chief Justice Roberts for enforcing constitutional obligations should be met with unified opposition. Public pressure works, and members of Congress need to hear that their constituents will not tolerate further attacks on judicial legitimacy. Second, share this video with everyone you know who cares about these issues. The mainstream media is already framing this as just another chapter in Trump's ongoing legal battles, missing the constitutional significance of what Roberts has done and why this moment is fundamentally different from previous legal setbacks. Your sharing helps this analysis reach people who need to understand what's really happening. Third, stay informed. Subscribe to this channel right now and turn on notifications, because when Trump files his response, when the compliance deadline hits, when contempt proceedings potentially begin, I will bring you detailed analysis immediately. This is history unfolding in real time, and you deserve to understand it without the spin and distortion that will dominate conventional coverage. Make sure you're subscribed with notifications turned on, because this story is far from finished. The emergency legal filings that will determine Trump's strategy will be submitted within hours. The compliance deadline is 14 days away, and if Trump defies Roberts' order, we could see contempt proceedings initiated against a former president for the first time in American history within 3 weeks. I will be covering every development, every filing, every legal maneuver as it happens. The next 72 hours are critical. The evidence has never been clearer, the judicial authority has never been more directly asserted, and the question has never been more urgent. Can our institutions still compel accountability from someone who has spent 8 years proving that defiance works? Drop a comment below and tell me which scenario you think is most likely. Does Trump comply, defy, invoke the fifth, or negotiate a narrow scope? I read every single comment, and I want to hear what you think happens when an unstoppable ego meets an immovable constitutional order.